Hey, this is Alex Zouzelas, author of the book Courtroom Confidential. Everything they don't want you to know about lawyers and more. Today I'm going to discuss JAV versus Trump, a case from the Federal District Court for the Southern District of Texas that has some people running around with their hair on fire screaming, "The federal courts have ruled that Trump can't use the Alien Enemies Act to deport dangerous gang members from Venezuela." As I'll discuss, that's not what the decision says. Just a reminder, I'm not giving legal advice, just analyzing a case to figure out what it really says. Before the president exercises his authority under the Alien Enemies Act, he has to make a public proclamation that he's doing that. The JAV case addresses why President Trump's proclamation was insufficient. It all has to do with the proclamation's wording in the context of two critical terms: invasion and predatory incursion. The Texas court did not rule that the president can't invoke the Alien Enemies Act to deport members of Tren de Aragua. Thus, the order is not a carte blanche ban of the president's authority to invoke the AEA, nor could it be, because Congress gave the executive, the president, that power in 1798. Instead, the district court in Texas ruled that the wording of President Trump's proclamation invoking the act was insufficient because it didn't set out sufficient findings to meet the meaning of those two terms, invasion or predatory incursion. The order actually provides guidance as to how to word a proclamation in order to survive judicial scrutiny. In my previous video, Keeping Kilmar in El Salvador, I discussed how courts have no authority to interfere with the president's political decision to invoke the AEA. The Texas District Court judge's decision clearly acknowledges that. The judge acknowledged that questions of a political nature, or which the Constitution and laws assigned to the president, can never be made by courts. The Texas District Court also acknowledged that the president's power to invoke the AEA is as broad as it gets and as unlimited as the legislature could make it. The judge, of course, was referring to the political question doctrine, which keeps courts out of the president's business when it comes to political issues, such as who's an enemy of the United States. In order to amplify how the political question doctrine keeps courts from interfering with the president's decisions on political matters, the Texas District Court looked back to a case from 1795, Martin versus Mott. In that case, President James Madison invoked the Militia Act and instructed New York's governor to call up the state militia because the War of 1812 was looming. Jacob Mott refused to report, so he was fined and all his property was seized. Naturally, he sued to get his property back, arguing he'd been unlawfully called into service. In other words, he was saying that the president didn't have the authority to invoke the Militia Act since, at the time it was invoked, the country wasn't actually at war with England. He lost because the Supreme Court concluded that the president is the sole and exclusive judge as to whether circumstances justified invoking the act. While the Supreme Court recognized the potential for the president to abuse that power, it said that the remedy for such abuse lay in the political realm, not in the judiciary, in other words, not with the courts. The Texas District Court also quoted from the Supreme Court's decisions in Luedecke versus Watkins and Johnson versus Eisentrager. In Luedecke, the Supreme Court stated, "The very nature of the president's power to order the removal of all enemy aliens rejects the notion that courts may pass judgment upon the exercise of his discretion." And in Eisentrager, the court noted, "Executive power over enemy aliens, unhampered by litigation, has been deemed throughout our history essential to wartime security." However, while the federal district court in Texas acknowledged that courts can't interfere with the president's decision to invoke the Alien Enemies Act, courts can interpret the meaning of the terms invasion and predatory incursion as they're used in the act in order to determine whether the wording of President Trump's proclamation invoking the act was sufficient or not. The Texas district judge determined it wasn't because, by failing to refer to or suggest that there's a threat of an organized, armed group of people entering the United States at the direction of Venezuela to conquer the country or assume control over a portion of it, the proclamation doesn't sufficiently describe an invasion for purposes of the AEA. As for a predatory incursion, the Texas District Court found that the proclamation doesn't describe an armed group of people coming into the U.S. as an organized unit to attack a city or other defined geographical area with the specific purpose of plundering or destroying property and lives. While the proclamation references that TDA members have harmed lives in the United States and engaged in crime, it doesn't suggest they've done so through an organized, armed attack, or that Venezuela has threatened or attempted such an attack through TDA. As a result, the proclamation also falls short of describing a predatory incursion, as that concept was understood at the time of the AEA's enactment back in the 1700s. So what's the solution? The president can change the language of his proclamation so that it conforms with the court's interpretation of the meaning of those terms. Once that's done, the Texas court acknowledged there isn't anything further the courts can do because the president's use of the AEA falls within the scope of the political question doctrine, making it immune from judicial scrutiny. Alternatively, the government can ask the Supreme Court to address the issue, which it might not want to do because an adverse ruling from the Supreme Court will make the government's effort to deport these Tren de Aragua members more difficult. The Texas District Court also recognized that the government can still deport TDA members under the Immigration and Nationality Act. It's also important to understand that the Texas District Court rejected the claim that deporting TDA members under the AEA violates the Convention Against Torture. One of the petitioners in the case claimed that if he was deported to El Salvador, which is where he'd be deported because Venezuela is refusing to take back any Venezuelans, he would be subjected to very harsh treatment in the CCOP prison. The court stated that federal law specifically barred such claims. Those are my thoughts on the Texas District Court's decision. Please post any comments you have. They always generate interesting discussions. If you like the content of my channel, please subscribe. Also, if you're interested in hiring me to research issues and draft pleadings under your supervision, or if you're a top-tier partner attorney looking to connect with a premier law firm anywhere across the nation, contact me at ZRWZ Onboarding, ONBOARDING @gmail.com. That email address is also in the description to this video. Thanks for watching, and I'll see you next time.